Thank you. Hafaday, good afternoon. The GMHA Special Investigative Committee of Iles Laturan Guahan is called to order. For the record, today is Friday, June 29, 2018, and the time now is 1:34 p.m. Notices of this meeting were sent as follows. First notice on Friday, June 22nd, 2018, and second notice on Wednesday, June 27, 2018. At this time, I'd like to ask our clerk to please call roll.
Senator Rodriguez.
Present.
Senator Torres. Senator San Augustine. Senator San Nicolas. Senator Esteves. Senator Castro. Mr. Chair, there is a quorum.
Thank you very much. I want to thank my colleagues for being here this afternoon. The purpose of this Special Investigative Committee of Iles Laturan Guahan has been approved pursuant to resolution number 345-34, and I'll read what the resolution is. It's relative to creating a special investigating committee that shall be authorized to investigate the administration and management of the Guam Memorial Hospital Authority concerning alleged coercion and or undue pressure of GMHA employees incident to the GMHA's modernization program, funding and accreditation, the providing of alleged false information to members of Laturan Guahan during official legislative proceedings regarding GMHA on January 22, 2018, the hiring, termination, and contractual decisions from January 6, 2011 to the present, which may or may not have been consistent with GMHA's mission and ethical standards, potential violations of the Sunshine Reform Act of 1999, and other laws, the financial audits and related information relative to the financial state and conditions of GMHA, and to determine civil or criminal liability implications, if any, in connection therewith, and to make recommendations, if any, concerning the same. I'd like to also state for the record and make it clear that this committee is solely limiting its agenda and an investigation to what has just been read on Resolution 345. There has been recommendations from another member of our body, Senator Uggan, to be specific, to add the department, the Guam Police Department, as well as CLTC as part of this agenda. However, when that suggestion was made, this resolution had passed already, and so we did check with the Legislative Legal Counsel, and in order for that to be included, a new resolution has to be introduced to either create a new committee or to amend the purpose and goals of this committee. And so I just want to say that for the record that there's no, the GPD issue or CLTC is not part of this committee's agenda. Okay, now we move on. A review of our standing rules, section 11.09, Special Investigating Committees. And I'll read what this section states. It's an organization, except as provided by these rules, no committee for the investigation of any special subject shall be authorized except pursuant to a legislative resolution, which shall be approved by an affirmative vote of a majority of the members elected to Iles Laturan Guahan. The subject and purpose of the investigation shall be expressed in the title of the legislative resolution, and the scope of the investigation shall be consistent with the subject and purpose so expressed. No such committee shall have authority to extend its investigations to subjects not so expressed, nor beyond the scope indicated in the legislative resolution. And this rule also includes the procedures for approval of expenses, the limitations, and the copies of these rules. And so I submit that all of this has been followed pursuant to Resolution 345, which has been adopted. At this time, we'd like to discuss and open for any discussions for the members is that the adoptions of our rules and what rules of engagement would this committee be using as we move forward in the investigation of the subject before us. Vice Chairwoman.
Mr. Chairman, before we go further into addressing the next order on the agenda, which is the adoption of rules, I want to discuss, if I may, a concern that I had with regard to Section 11.09 of our standing rules, the Special Investigating Committee. If you look at Section A, which you read previously, at about 1, 2, 3, 4, 5, 6, at about line 6, the sentence there begins, and I'll read it again. The subject and purpose of the investigation shall be expressed in the title of the legislative resolution, and the scope of the investigation shall be consistent with the subject and purposes so expressed. The point that I want to raise to the committee, and perhaps there may be a need to revisit the resolution in its entirety, is if we look at the scope of the investigation being consistent with the subject and purposes expressed in the resolution, then I believe that the last item on the resolution, which is number 6 on line 15 of page 3, I believe that that line, as it reads, and reading directly, it reads, determining civil or criminal liability implications, if any, in connection therewith, and making recommendations concerning the same. I believe, Mr. Chairman, that if we refer to our Mason's legislative manual with regard to investigations, and this is specifically at section 797. 797 of the Mason's legislative manual addresses limitations on the right of a legislative body to investigate. And specifically on number 2, it states that the legislature has no right to conduct an investigation for the purpose of laying a foundation for the institution of criminal proceedings, comma, for the aid and benefit of grand juries in planning indictments, comma, for the purpose of intentionally injuring persons. Mr. Chairman, if I may, I believe that if we were to take the literal adoption that the scope of the investigation shall be consistent with the subject and purpose so expressed, it is my understanding that line 15 of page 3 of the resolution may not be consistent with the limitations on the body to investigate. And so I'm raising that point of concern. I understand that there is a general belief that should something be uncovered, that it shall be turned over to judicial bodies that have jurisdiction. But in the wording of this resolution, that it is this committee that shall determine civil or criminal liability implications, I'm of the personal opinion that that is perhaps superseding what the legislative function is, and that function is solely a function of either the executive branch or the judicial branch. So to get to the point, I'm just raising a concern that if in an overabundance of caution, perhaps that 6th item should not be a part of our scope, which we are purporting is going to be the scope of our investigation.
Thank you very much, Vice Chairwoman. I want to acknowledge Senator Nelson as well. Thank you for being here. And we can entertain a motion at this time to strike off as part of our scope is item 6 of the resolution. However, with the understanding that when the report, the completion of this body's investigation, the report, that it's going to be made public, and at that time could be provided to any authorities who have jurisdiction of that at that period of time. Senator Esteves?
Mr. Chairman, to highlight the statements made by the previous speaker, I do share in the concerns with regards with the adoption of the rules and our current standing rules with regards to investigation. However, I do believe that regardless of whether it's within the scope of the resolution in this committee or not, we're duty bound, I believe, to report any suspicions of anything criminal to the proper authorities for them to do within their scope and their jurisdiction. And so I think in keeping with the spirit of the law and what we intend to do here, regardless of whether or not it's in the resolution, I don't believe that that would preclude us from forwarding any suspicions of improprieties to the appropriate body. So I make the motion to strike item F on number 3 on the goals of resolution 345-34 to remain consistent with our standing rules.
Okay, there's a motion. Any discussion? Are there any objections or discussion to that motion by any of the senators, the members present? Senator San Agustin?
If Senator Tevis can just repeat exactly what he said, because I just want to make sure it's quite clear that as a result of the investigation, if there is civil or criminal liability, so let it be. And I believe exactly what Senator Torres brought up, the co-chair, is that if there's any criminal liability, we should understand that we need to pause our investigation at that point. At any point that is determined that it's criminal, we want to be able to forward it right away so that it takes the appropriate action and without any delay. I mean, everything else we can reveal, but we need to understand that because of the sensitivity of the case. When it becomes criminal, it's a different. It falls in a different umbrella, and the AG's office and the courts will be looking at that. Did we taint? Did we destroy the evidence? Did we manipulate it to the point where nobody can get prosecuted? I want to make sure that we understand that. But I can agree with the eliminating F and striking 6 on the resolution, but I just want to make sure that we all understand that throughout the investigation, things are going to come out. And at what point do we draw the line? Because we're not going to determine it, the investigation body, as I look at our goals. The investigating body is going to reveal this, and we'll be bound by the people of Guam that we reveal everything. And that's what I'm worried, is that, I just don't want us to get tied up on things. Okay?
If I may, Mr. Chair, but I just want to remind people the operative word here is determining. It is not within, and it's spelled out in our limitations of investigation. We ourselves, as this investigative body, does not determine civil or criminal liability. That's for another body. However, you are absolutely correct that in the course of the investigation, if things should surface, then that's where another entity, another judicial body or the executive branch will then take it up in that course. So it's just that act is beyond our scope as a legislative body, and that was my my caution. Thank you. Thank you.
If I may, we can take a 5-minute recess. Okay, thank you. thank you. We're back on. It's 1:52. The committee is now called back to order. Before we broke, Senator Esteves, you still have the floor.
Thank you, Mr. Chairman. Just to confirm where we left off, the motion to remove item F, that motion was carried?
No, that's still pending. And that, just to be clear, the motion is to remove item F from our scope of investigation for this committee.
Yes.
Okay, on this committee level.
Yes, and I rest with that,
Okay.
Mr. Chairman.
Are there any objections? Senator Seneklis, recognize.
Thank you, Mr. Chairman. Pursuant to what was mentioned by the Vice Chair of the committee, the Mason's manual is subordinate to the resolution. And so while Mason's manual does state that there wouldn't be any civil or criminal determinations coming out of an investigative committee, because the resolution supersedes the Mason's manual, and the resolution does call for the determining of civil or criminal liability implications, if any, we can actually make those determinations. And I want to point out that I believe in Section 6 of the resolution, the operative word is implications. We're not rendering judgment. We're not levying charges. We're just saying if there's anything that implies civil or criminal liability, we can make a recommendation that action be taken to investigate that further by the appropriate authorities, whether it's the Attorney General, whether it's the Guam Police Department, whether it's the Federal Bureau of Investigation. And so I'm of the mind that we should keep that section in our goals, because if in the course of all of the other items, if we do find something that should be recommended by the committee for action, I think that it would be better for us to do so as a body and forward that recommendation to the legislature as a whole, where all 15 senators will determine whether or not they are going to uphold what our findings are. So I think that we should keep the goal in making those kind of determinations, and I think that it would also be better for us to do so as a group, so that if all 6 of us or 5 of us make a recommendation that an investigation should be warranted for any implication, then it's a majority decision as opposed to a single senator trying to take a finding and run with it, so to speak. So I think it'd probably be better actually for us to keep this as one of our goals. That's my input, Mr. Chairman.
Mr. Chairman, I mean, based on discussion brought up by my colleague, and even though the operative word is determining, I think he brings up a very good point that it is specified implications thereof, which doesn't mean we are the adjudicating body, or we are not the final adjudicating body. We don't make the final determination. And with that, Mr. Chairman, I will withdraw my motion to strike item F.
Okay, the mover, so that motion to delete item F has been withdrawn, so we're still back on. So everyone good with the scope that we have in front of us? Okay, great. So now we will move on.
My apologies, Mr. Chairman.
Yes, you have the floor.
Based on the discussion we had with legal counsel, if we could just put on the record and make it very clear, I think it goes without saying, but just so that we're clear as a committee that the findings and information that's to be reported to the body after our investigation is complete is always towards the goal of potential legislation to maybe rectify these issues or address things that are in the findings. Is it okay if we make that very clear in the committee that that's what we're aiming to do?
Great. Thank you very much, Senator Esteves. I want to reaffirm those statements. When we first introduced this back in February, those statements were made very clear that this body was not moving in this direction for any other purpose but to ensure that after the completion of this investigation, that if there's any type of legislative action that needed to be done in terms of any revision of law or creation of new law, that would be the goal of this investigation.
Thank you, Mr. Chairman.
Okay, thank you very much. Any other senators on this item, on the review of goals contained in Resolution 345? Okay, if not, we'll move on now to to the adoption of our rules. And the suggestion, and we can get a motion for this, is that we use our Mason's manual investigations by legislative bodies as a guide as we move forward in this process. Senator Steves?
Senator Steves, Mr. Chairman. Item 5, if maybe, since this is going to be in the record, this legislative meeting, and based on consult with legal counsel, if maybe we can add to 5A that we're adopting rules from the Masons Manual in terms of procedure, but rules that are not inconsistent with our own rules based on the hierarchy. Maybe if we can add that section in at the end of A, so with bodies, comma, not inconsistent with rules, standing rules of the 34th Guam Legislature.
That's correct, Senator, and which does take, it's the first order that...
Now, would we be able to just add that in so it's just very clear in our records that the adoption of the rules and what we're, I understand it's well understood in many respects, but since this is for the sake of the public, since this is an open record, that we just maybe add that in. I'd like to make that motion.
Okay. On that motion, are there any discussions?
Yes, Mr. Chairman, if I could just put this on the record, the specific language. Perhaps after the word bodies, we should put a comma and put the language and have it read subordinate to the standing rules of the 34th Guam Legislature and the scope of Resolution 345-34.
I'm fine with that language, Mr. Chairman.
Okay. There's a second on the motion. Are there any objections? If none, the motion carries. Thank you. We're now on item 6. We'll entertain any motions. What I'd like to submit to the members of the committee is that in order for us to be able to accurately ensure that this process of investigating the items that we have just adopted are done in a proper way, done by experts and professionals, is that we look to a third party investigator, whether it be an investigative provider, an attorney, that would assist the committee in looking at these items that we have just approved. That's something that I would like the committee to consider at this time.
Mr. Chairman, if I could add to this, based on my experience with the investigation with the Ethics Committee, I'd like to make the motion to increase that. And my reasons being is because there is a process in the legislature when it comes to procuring service, and this is probably going to be a contract that goes out. And so there's going to be a limit on that. Now, we don't have to contract for the full amount of the $50,000, but ensuring that this body adopts an amount, and that way either one stipulated in the contract up to a certain amount, or if we put a limitation to where the committee can revisit. But the contractual process does take a while, and I believe that if we go past the $25,000 cap, because whether we're using if we're using investigative services, they're billable hours with reimbursements. So it's quite possible that based on one initial run in the investigation, we go through that $25,000 real quick. The timeline of getting another contract in place could hinder progress of this committee. So I'd like to make a recommendation that we increase that amount to $50,000. I think with the understanding that we don't need to have the contract reflect $50,000 right off the bat, but we know that money's available, and kind of be proactive in based on the processes we have in operations of the legislature.
Okay, just to be clear, the committee here could make a recommendation of how much the committee intends to expend for the purposes of investigation.
Yes.
However, the Committee on Legislative Operations will need to make that authorization on any expenditure of the committee. And so there's that second process that would need to be made. So what we do need here now is just a consensus among this committee that this is the amount that we're committing to go up to and not to exceed. And so that's why I put that before, because we still have to go through the Legislative Operations Committee to seek their approval for any type of expenditure. And so I would, as chair, I would submit that this amount would probably be an amount, the $25,000 amount would probably be an amount that we should stick with, and we shouldn't exceed at this point in time of the investigation. At this point in time,
I'll defer to the recommendation of the chairman. I just wanted to bring that up. Thank you.
Okay, thank you very much for that. So is there a motion or any discussions on this?
The motion to accept the item A on number 6.
Okay, Senator San Augustine, you have a motion to authorize the chairman to procure investigative services not to exceed $25,000. Is there any discussion on this item or any objections?
Mr. Chairman, the scope of, in terms of either qualifications or is the committee going to be able to look at or validate what exactly we're looking at within the scope of investigative services? So for hiring investigative services, what does that include? Is that something that we're going to be revisiting as a committee to make that determination as to what's the scope of the services that we're going to be paying for? Or I don't know if you'd be able to elaborate.
Yes, and so it's my intention that anything that we do moving forward in procuring the services of a third-party provider, that the committee would have a purview, would have the ability to review the scope of work before it is finalized by this body.
Thank you, Mr. Chairman.
Okay.
I second the motion to adopt item A, or item 6A.
Okay, thank you. Are there any objections to that? If none, the motion carries. Item 6B is now for discussion, is for this committee to allow public testimony at a time for like this meeting, which is our first initial meeting, which really is our housekeeping, and for any other meeting that this committee calls on. We want to ensure that there is a part in the agenda that allows for the public to provide testimony. Okay. Any discussion?
May I ask, Mr. Chair, is this intended, in looking at the, again, I'm just referring to the Masons Legislative Manual because it does have specific guidance on legislative investigations, including witnesses, compelling witnesses, the right to subpoena and the like. And so is this item B intended to include public testimony that is not specifically called upon by this investigative committee? Because I'm thinking about the nature of an investigation where witnesses are called upon to speak on something of concern or relevance to an investigation. And in that regard, I don't understand what is meant by public testimony if it's intended to be an unsolicited opportunity for people to just produce information, whereas in looking at the investigative nature that's contained within the Masons Manual, it's contemplated that people who appear are called upon to appear, and there's specific information that is being sought by the committee. So I'm just asking about the open-ended nature of this motion 6B insofar as allowing public testimony.
Thank you very much, Senator Torres. This would cover for procedures such as what we have here today, which is the public committee meetings. If we are open to allowing those in the public who are here to provide any information or testimony, that's really what this is. When we do procure the services of an investigative provider, that investigative provider would now be deputized and be able to issue subpoenas on behalf of the committee. And so those types of information that may be sought at that period of time will be, the authorization will be there at that moment in time. And so for this, it's just to allow for any public testimony at meetings such as what we have today.
Mr. Chairman, while I do, I'm sorry, I respect the ability for the public to provide testimony. I think it's crucial to this, but considering the massive scope and the amount of information that we're going to have to be going through, my recommendation that even in these types of meetings, which are very public and transparent, that the committee accept testimony in writing, and we can make the determination by vote if we're going to accept the public testimony, because we want to ensure that it's within the scope of what we're trying to do in the resolution. And so if we review it, if we're able to review it and it's open-ended on the receipt of public testimony and it's made available for the public record, it would allow the members of this committee to review the testimony prior to and make the determination whether we want to adopt that testimony within this committee because we feel it's within the scope of what we're doing here. But I think I would caution against a very open-ended public testimony, which may pull us out of our scope and turn to a marathon oversight hearing, which is really not what we're trying to do here, Mr. Chairman. So I think if we adopt this part of our operations and how we're moving forward procedurally, I think that should be based on written testimony, open-ended written testimony. Anybody can submit from the public written testimony. And I think because this committee has the ability to subpoena, like anybody making a public statement, right, especially an accusation, I think to potentially protect from liability, there's always an affidavit attached where there's a certification where whoever's providing the testimony is doing it in truth. And so even with the ethics investigation, if somebody's going to file a complaint, they submit it with an affidavit saying, I affirm this to be true under perjury of law. And I think that's a compromise we can make, allow for open-ended public testimony. Anybody can provide it. We can even decide whether or not we want that public testimony to be confidential. But I think it's important to have that liability statement that what they're saying and submitting as official testimony, especially with the potential for this committee to adopt it as fact and evidence, that there be that affidavit attached to it and that the committee be allowed to review it and make sure that if we adopt that information and include it in our work as fact from that point on, or as evidence as that point on, that it is within the scope of our goals. So I'd like to make those recommendations to that motion, and I'm open to discussion from my colleagues on their thoughts.
Okay, thank you, Senator. Senator Nicholas?
Thank you, Mr. Chair. Several items. The first is my concern about the public testimony component is that there is also a possibility that as findings pour in from the investigation, those who are identified in the findings or who are found culpable or responsible based on those findings might use the public testimony window to turn it into a debate. And because we're on a tight timeline of 120 days, I'm concerned that those affected parties might also try and filibuster the work of the committee by just constantly coming in and debating the findings as they pour in, and it could stretch out our timeline beyond the 120 days and cause our committee's efforts to lapse. My other concern, Mr. Chairman, is I very much support the involvement of the public and the transparency. However, there's also a need for us to have a mechanism by which the committee can receive confidential information, because there may be parties who would want to direct the committee or point out to the committee certain areas to investigate. And those parties may not want to reveal themselves because of workplace concerns. So I think that the suggestion of getting testimony in writing is a good suggestion. I think that perhaps as a part of our process, we should set aside a period certain for public testimony, perhaps, like of our 120-day timeline, we set aside 3 to 5 days of public input. We may want to consider, do we want to have that public input before or after the investigative findings are released? Because if it's before, then it wouldn't turn into a debate as to whether or not the investigative findings are something substantial. If it's after, we open the door for those findings to basically be argued about. So that's something that we may want to consider. And we also, I think, should consider creating a mechanism within our operation that allows for the receipt of confidential transmittals. So I'd like to just kind of put all of that on the table But I am concerned about just having, as a part of our regular proceedings, public testimony on an ongoing basis. Thank you, Mr. Chairman.
Thank you, Senator Nicholas. So we take note of the discussion, and I think they're worthwhile discussion. So at this point, we'll take a brief recess. We'll consult with legal counsel so the appropriate motion is made moving forward. So we'll take a short recess. Thank you. Thank you. We're back on. It's 2:17. And so there's a motion to strike motion B altogether. with the we're making it very clear that the public is welcome to provide this committee any information, any testimony that it wishes to provide as it deals with the scope of our investigation. And this committee, once it's received, will make that call on a case-by-case basis whether those testimonies, written testimonies, will be part of the record or not. Clear? Okay. Senator, you second the okay. That was your motion, Senator Esteves. Thank you. Any objection to that motion? If not, the motion carries. Next item is our calendar and the agenda. And so at this time, the committee will now move forward with what it has been authorized to do, which is to seek a third-party provider to investigate these goals. And at that time, when a meeting is necessary, that meeting will be called pursuant to the open government law. Okay? So any final remarks from any members of the committee?
Just real quick, Mr. Chairman, just for the sake of transparency, because I had mentioned, and I would just like input from my colleagues moving forward, because there's going to be a lot of information. My request to you, Mr. Chairman, is as we identify items of interest, I'd like to, if we can, develop some sort of brevity code to make it easier. It's a lot of information, and so if we're having to go, this report, this item, this section, this page, this number, when we do come together, it's going to definitely be very time consuming. And I think if we can just, once we've voted on specific items as items of interest, then we just slap it with the code so we're always on the same page and we have quick reference. It's just a little bit of housekeeping, Mr. Chairman, but I do believe it'll help us in moving forward to really focus in on particular items.
That's noted. Thank you very much, Senator. Any other discussions, Senator San Nicolas?
Just an observation. Did we want to set a minimum qualification requirement for the investigative services that we're going to be procuring, like a license? Do we want to have that be a licensed investigator and make that perhaps be part of the motion as opposed to just a general procurement of investigative services, but then technically we can go out and hire anybody? And the concern is that also another observation I had was in the course of these findings, we also need to be very careful about HIPAA and the patient privacy rights. We need to make sure that whoever goes in and investigates is doing so not only to report back to the committee, but mindful of the fact that there are definitely going to have to be lines drawn around where they can and cannot go, or what they can and cannot see. So those are just observations I wanted to put out there as we move forward, because the resolution does have a broad scope in terms of what it's intending to determine, but we just need to be careful that we're not going to be overstepping into any privacy rights over the course of making those determinations. Thank you, Mr. Chair.
Thank you very much, and that's noted, Senator. On the first question, we intend to ensure that when we do procure the services of an investigator, it'll be through our legislative professional services contract, and the requirement for that be a licensed entity that does provide that services. So we'll ensure that. And also to, of course, to avoid any other costs associated with this process, we're going to utilize the services of legal counsel for the Committee on Health, and that as much as possible be able to look to our legislative counsel too for any assistance and guidance, as much as possible.
Mr. Chairman, if I may, just to highlight the concerns with my colleagues with regard to HIPAA certification, if I may be so bold, that we just request maybe from the committee members that we all get our HIPAA certification. You can do it online, takes an hour, lasts for a year before you have to get recertified. But I think because of the nature that we're dealing with, and just so everybody has the same comfort level and we're not getting any pushback from the hospital based on the information that we're going to receive, it's very easy to obtain. And I just put it out as a request that maybe the members of this committee can just go knock out the training online, and we're all HIPAA certified. We're well aware of the law, and because we're going to be handling a lot of information, I think it would just, anybody providing us information or testimony, I think might feel more comfortable from us having that.
Thank you, Senator. That is a very good suggestion. So the members here would, okay. Right, next item. Before we do that, Vice Chair, do you have any comments?
I just, for the purposes of the listening audience, I wanted to ask you to discuss what the 120-day timeline is approximately based on this resolution. So that would bring us into about what day? Do we have that? Starting from today. So generally it's 120 days from today.
And thank you, Senator. And so as we now move forward, we seek the services of a third-party investigator. The timeline can be more clear at that point in time. However, the 120 days will start after this meeting today.
Just to clarify, Mr. Chairman, the resolution does read that it's 120 days from the passage of the resolution. And so we may actually be well into the 120 days since the resolution did pass a number of days ago. So just for the record.
Okay, so noted, and thank you. So we'll move forward in that matter. Okay. Senator Sonogsin, you said you had a motion?
A motion to adjourn.
Okay. Okay, great. Any objections? No objections. This committee is adjourned at 2:23 p.m. Thank you.